Court does call the cases of the people of the state of Michigan versus Jeffrey Wayne Bloom. There are two cases. I will call both of them 22 FB 1278, 22 FB 1276.
This case opens with a tension level most courtrooms never reach. Before Judge Simpson even settles into routine procedure, the energy shifts. Because today's defendant, Jeffrey Bloom, is not just any defendant. Court staff already warned the judge that Bloom has been acting out in extreme ways behind the scenes. Conspiracies, threats, unpredictable outbursts. This isn't just a routine preliminary exam. It's a safety-critical situation where every word, every movement has consequences. And Judge Simpson knows it. His tone isn't dramatic. It's controlled, measured, and unmistakably serious. When a judge begins by calling two cases tied to the same defendant, it tells you immediately the stakes are layered, multiple charges, multiple incidents, and a history that has already tested patience and procedure. As viewers, pay attention to how early decisions set the tone for the rest of this hearing. This isn't just about guilt or innocence. It's about control, security, and whether a defendant can even be trusted to step foot inside the courtroom. This setup already raises the question, how do you maintain due process when the defendant himself becomes the biggest threat to it?
Counsel, state your appearances.
Morning, RG. We have Jeffrey Bloom on both matters.
And Amy Reiser, bring on behalf of the people on both matters.
Before, can you let Arnett know to bring Mr. Bloom in through Zoom, please?
Come out the window, Mr. Bloom. Okay, you gotta let them know that.
We have called the case of the people versus Bloom. I had apprised counsel previously that I had reconsidered based upon the defense counsel's motion to allow Mr. Bloom back into the courtroom this morning, and that's where we were preparing. This morning, my office received an indication that Mr. Bloom had been seriously acting out, making claims of conspiracies and whatever he may want to say, but also then began to threaten jail staff. And he said, and it is reported that he stated that when he was taken into the courtroom this morning that he was going to try and disarm an officer, aside from his threats to assault officers and throw feces on them.
This is the moment where everything shifts from concerning to outright dangerous. Judge Simpson isn't exaggerating. He's reading documented statements that Bloom allegedly made just hours ago. Threats to assault officers are already serious, but the claim that he intends to disarm an officer inside the courtroom is on a different level entirely. From a legal standpoint, this changes the judge's obligations. Courtrooms are required to maintain safety, not only for staff, but for attorneys, witnesses, and even the defendant himself. If a defendant clearly communicates intent to cause chaos, Michigan law allows, and even expects, the judge to remove that defendant from the courtroom environment and proceed via remote technology. This is also where you see what separates a seasoned judge from an inexperienced one. Judge Simpson doesn't speculate, doesn't emotionally react. He focuses entirely on safety protocol and the credibility of the threat. And credibility matters. If statements come from jail staff, especially involving direct officer threats, courts treat that as reliable intelligence. Now here's the engagement question. Do you think a defendant who makes violent threats should still be allowed in the courtroom? Or does remote attendance become the only responsible option? Let me know what you would decide if you were in the judge's seat.
So I made the decision early this morning that he would not be brought up to the courtroom, and then would inform counsel of that decision specifically and why I made that decision on the record. There is, I will say, also some difficulty. I mean, we can proceed, Mr. Killewald, but and he can hear these proceedings. So, I mean, I am at this point ready to proceed, but I don't know what your feelings on it are, sir.
Well, Your Honor, since the last hearing, I've seen Jeff a couple times. I saw him last night for over an hour. I had not anticipated this at all. I had anticipated him being here. Your Honor, I don't minimize anybody threatening anything, but sometimes people say things that just.
You know what, Mr. Killowald, if you want to go there, and I'll let you make the record, but I take those threats very seriously.
And again, I'm not minimizing that, Your Honor. All I'm saying is, would you just please give him a chance this morning to sit here?
Under these circumstances, absolutely not.
You're witnessing a rare moment of courtroom frustration spilling into the open, and it's coming directly from the defense attorney. Mr. Killerwald initially painted a picture of a rehabilitated client, someone ready to participate respectfully in court. But now he's forced to confront the exact opposite reality: threats, aggression, unpredictability, and a defendant who seems committed to escalating the situation. Judge Simpson's pushback here is significant. When he says absolutely not, it's not about punishment. It's about preventing a catastrophic scenario, because if Bloom follows through, every deputy in that room becomes a potential target. Judges do not gamble with officer safety, ever. But here's the deeper issue. When a defendant behaves this way, the defense's credibility starts to erode. Judges rely on defense counsel to present reliable assessments, and Killerwald's insistence that Bloom was suddenly well-behaved now clashes hard with the morning reports. And this right here exposes a long-standing tension in criminal court. How far should defense attorneys go to defend a client whose actions make the courtroom unsafe? Some will say the lawyer must always advocate aggressively. Others argue that safety overrides everything. Where do you stand?
You were the one that kept repeating to this court that somehow or another he had been rehabilitated, that he would be able to conduct himself. And then when he's down there, he's making threats, not only to those officers down there, but he's making threats about what he intends to do in the courtroom. And so quite frankly, and you know, the folks that would be bringing him up and the jail staff and everything, I have an absolute confidence in. But to make a threat that he is going to disarm an officer in this courtroom, it would be absolutely irresponsible of me to bring him up. He has already laid out what he wishes to do.
This is a conspiracy, Your Honor. It's not true.
Your Honor, I assume if I ask for an adjournment for a week or so I could go back and talk to him and figure out what's going on, would the court grant that, or?
I haven't heard from the people. I mean, they have their witnesses here, and
We would object to any adjournment, and are ready to proceed to conclude the proceedings today. If the defendant is present by Zoom and he can clearly hear us and can see the proceedings. And I don't feel safe having him brought in the courtroom either. So we're ready to proceed. I do not want to adjourn.
Here we see the prosecution drawing a firm strategic boundary. While the defense seeks an adjournment, likely hoping for more time to manage their client's behavior, the prosecution makes it clear they're ready to move forward today. "We're ready to proceed" is more than routine language. It's courtroom pressure. Remember, prosecutors have witnesses standing by, including officers and civilians. Some may have taken off work, rearranged schedules, or traveled significant distances. Courts heavily weigh the inconvenience to witnesses when considering adjournments. And in Michigan, once witnesses are sworn and present, judges are reluctant to delay unless absolutely necessary. Another key detail: the prosecution emphasizes that Bloom can hear and see the proceedings via Zoom. This neutralizes the defense's core argument. Legally, remote participation is considered sufficient when the defendant's own misconduct is the reason they can't be present. This moment matters because it shows the prosecution shaping the narrative. Bloom is volatile. Bloom made threats. Bloom should not get benefit of the doubt delays. And above all, justice should continue without rewarding disruptive behavior. Engagement question for viewers: do you think the prosecution is pushing too hard to proceed, or are they right that delays only empower threatening behavior?
I'll leave to your discretion, Your Honor.
if you wanted an opportunity, Mr. Killowald, to speak to him prior to beginning, I certainly would afford that. I am disinclined to adjourn the matter.
Would they bring you up to one of the waiting rooms? Or do I have to go down to the jail?
Either you have to go down to the jail, or you would have to, you would have to have some device to sign on to, and I could put you into a breakout room with them. Either way you'd like to do it.
Well, I have Zoom capabilities, so if I can get a number, I'll just.
It's the same one you use every Thursday coming here. But if you sign into here, and then I can put both of you into a breakout room and you can go into.
Do you have the link up or do you need it? Do you have the judge's link or do you need it?
I know it's 462 and I know it's 142022, but I forgot the rest. What is it?
Ms. Tang, is there any way that you could send a link to this courtroom to Mr. Killowald?
This moment captures a fascinating modern reality of courtroom procedure, the integration of digital communication as part of live hearings. 10 years ago, the idea of an attorney joining a breakout room via Zoom during a felony case would have sounded bizarre. Today, it's routine. But this case elevates it to necessity. Judge Simpson is troubleshooting in real time. He's managing the logistics of ensuring the defense attorney can communicate privately with his client, despite the defendant not being physically present. This speaks volumes about how courts have adapted to balance safety and fairness. What's notable is how calm and procedural the judge remains. Despite the chaos surrounding Bloom's behavior, Simpson is still ensuring the defense has full access, full communication, and full opportunity to prepare. Courts must maintain fairness even when the defendant does not. For the audience, this moment highlights the behind-the-scenes pressure judges face. They must simultaneously maintain safety, protect constitutional rights, manage schedules, ensure technical access, and keep the entire courtroom moving. That's a heavier load than most viewers realize.
Yes, Judge, I'll do that right now.
Thank you.
That's crazy. Who's behind that? Who's behind saying some crap like that? That's crazy.
We just sent it to your email. Oh,
Good morning, Your Honor. I'm sorry I haven't even been able to say good morning. Apparently you can't hear me.
You can hear.
You can't hear me. You would acknowledge me. Wouldn't you acknowledge me? Can you find out if I'm being heard? You're the court officer. I'm asking you, can you find out if I'm being heard? Or are you going to violate my rights too?
you signed in, Mr. Killowald.
I just did, but nothing's happening.
Is he? He's not in our waiting room, is he?
Are you going to find out? I'm going to write a grievance on you, and I'm telling you right now, I'm going to light you up big time. If I'm not able to at least address the court and say good morning, Your Honor, I don't know, what am I supposed to do? This is crap. I don't understand this. I'm being railroaded. That's what it is. I understand. The judge already allowed me. Look, I have a piece of paper right here. Why would I all of a sudden, the day before court?
He's going to have to step out, but why? I don't see him in the waiting room yet.
Why would I all of a sudden, the day before court, make threats to disarm an officer? How the hell I'm going to be shackled and handcuffed? I'm 150 pounds. How am I going to do that? I'm a weakling. I'm an old man.
Here we finally hear from Bloom, and his statements are revealing. He insists he's physically incapable of attacking anyone, calling himself an old man and downplaying the seriousness of the threat reports. But this creates an immediate credibility conflict. Jail staff reported that Bloom made explicit threats, yet Bloom is now portraying himself as harmless and misunderstood. This disconnect is crucial. Courts rely heavily on correctional officers' documentation because those officers observe defendants in unpredictable, unstaged conditions. When Bloom claims the opposite, it doesn't erase the prior threat. It simply highlights his instability. This is also a classic defendant tactic: minimize, deflect, and frame oneself as the victim of misunderstanding. But you'll notice Judge Simpson doesn't respond emotionally. He doesn't entertain the theatrics. His role is to focus on safety and facts, not persuasion attempts. Legally, even if Bloom didn't intend to follow through, the mere threat is enough to restrict his access. Threats against officers, if believed to be credible, justify remote appearance without violating rights. For viewers, do you think Bloom is being honest here, or is this simply damage control after a morning of aggressive behavior?
You should get, oh, okay, there he is. So you can throw Mr. Bloom and Mr. Kilowog away. And while they had their conference in the waiting room, we can go off record. 14A stands in recess.
You cannot do this, it's illegal.
Your Honor, I got Mr. Bloom for you.
Back on the record in the case of the People's State of Michigan versus Jeffrey Bloom, there has been, after the initial indication to counsel that I wasn't going to bring the defendant up in my statements as to why, that he was going to be in a remote location, the Washington County Jail, during the course of his preliminary examination, I have and will indicate that there's been a request by Mr. Kilowog to adjourn the matter.
This is a pivotal procedural moment. Judge Simpson does grant an adjournment, but only a brief one. This move reflects a balancing act between the competing pressures of fairness and efficiency. The judge understands the defense must communicate under unusual conditions due to Bloom's removal from the courtroom. However, he also respects the prosecution's preparation and the presence of witnesses, so he chooses a narrow middle path. A short adjournment, just long enough for defense counsel to handle logistics and prepare properly, but not long enough to derail the prosecution's schedule. This is judicial discretion at its finest: practical, measured, and strategic. He even outlines how scheduling will work, making sure witnesses aren't inconvenienced unnecessarily. This is important because courts must avoid wasting public resources, including time. One subtle but powerful moment: the judge states clearly that Bloom's instability impacts scheduling decisions. This signals something deeper, that Bloom's conduct is now shaping the entire courtroom calendar. Which leads to a key question for the audience. Should defendants who disrupt proceedings face tighter judicial control, or should judges be more flexible to avoid potential claims of unfairness later?
In looking at scheduling, but particularly for, as the prosecutor's office, or Ms. Reiser has a number of things that are going. And next week, in the next few weeks, in trying to get this done, but also balancing that against the sort of change in how Mr. Kilowog may have to communicate with Mr. Bloom. The court has decided to adjourn the matter, but it will be a very brief adjournment so that Mr. Kilowog and Mr. Bloom can go through their logistics of communication and the like. So I'm adjourning it to this Thursday, November 10th. I'm adjourning it to 2 o'clock. The understanding, however, is this, that Ms. Reiser has a number of different things before Judge O'Brien that day, which she needs to conduct by Zoom. The court will allow whatever leeway is necessary to make sure she can conclude those matters, because she's here ready to go today. And so whatever time that means, once she's done, whatever time that means we have to start after 2 o'clock, we will. She can coordinate with civilian witnesses or her witnesses to make sure that they're here and not sitting in the courthouse wasting their time. I don't expect that we will begin right at 2:00. I also understand Mr. Killawald has some other matters before Judge O'Brien. We will just go when all of that is concluded. There is one other issue regarding the witness that is currently incarcerated at the Washtenaw County Jail. There was a request that she be able to appear via Zoom regarding her testimony. Having heard from both sides on that, she'll need to appear in person, and we'll have to figure out a way that she's brought up. I will, although it's Judge Washington's decision and the jail's decision, she has a matter before Judge Washington on that day. And I will be sending a message to Judge Washington asking that she not, if there was a PR granted, that she not be released until the conclusion of her testimony in this case. I think I have covered everything.
And I would just indicate briefly, Jenner, that we did take a recess this morning after the information regarding
Hold on. Okay, go ahead, Ms. Rose.
right, we did take, after the information provided to counsel and myself about Mr. Bloom threatening the corrections officers and making statements to disarm them. Your Honor put that on the record regarding that Mr. Bloom would not be brought into the courtroom. At Mr. Bloom's insistence and demanding and Mr. Killawald's request, we did take about a 45-minute recess so Mr. Killawald could go down to Mr. Bloom and get the questions that he had prepared. So it's my understanding that he did meet with Mr. Bloom again today, did receive those questions, and now is requesting an additional adjournment for these extra days. I did place my objection on the record. We're ready to proceed and would like to conclude this matter. And he will not be brought into the courtroom. And I also indicated for Mr. Killawald and for Your Honor that I believe the testimony, in addition to the information we learned from the corrections officers this morning, the R&O testimony in 22 FB 1276 would involve what is referred to in the business as suicide by cop. When the officers went to arrest him after the assault and sexual assault, he was acting as if he had a gun or something behind his.
Your Honor, I'm sorry, I don't mean to interrupt, but that's an argument for Your Honor to hear. I mean, we've got the adjournment of the cases. I don't understand why we're making these arguments.
And I'm not making an argument, I'm placing it on the record. When Mr. Killawald comes back on Thursday and wants his client back in the courtroom again for the 4th or 5th time, I think it is a serious safety concern that he should not be brought into the courtroom. That the facts of the case, this is what I anticipated that it will show.
Judge, just for the record, again, I met with my client this morning. He claims he had an asthma attack, but that was not properly addressed. He got irritated. He tells me he never made any threats to the officer.
Well, okay. And all of that's fine. I want to make it very clear, and I did to counsel at the bench, regardless of, and certainly those indications and arguments can be taken into account. The court has taken them into account. Under no circumstances, given what we've been through in this case, given what Mr. Bloom himself has done, and is he going to be permitted to be in the courtroom during the course of this hearing? He will participate via Zoom. And there will be adequate facilities for him to be able to participate in that manner. He has forfeited the right to be here. And that's this, on that issue, that's this court's final ruling. So I'm not entertaining anything else regarding it.
Judge Simpson delivers a definitive ruling. Bloom will not be allowed back in the courtroom, and the decision is final. This is one of the strongest judicial statements you will hear in a preliminary hearing. When a judge says, "I'm not entertaining anything else," that shuts the door on further debate. Legally, this ruling is airtight. Bloom forfeited his right to appear in person through his own behavior. Courts have long held that a defendant can lose certain procedural privileges when they pose a credible threat to safety. What's extraordinary here is the combination of documented threats, officer testimony, and Bloom's history of outbursts, all of which support the judge's conclusion. You can also sense the judge's exhaustion. This isn't the first time Bloom has pretended he can't hear or attempted to manipulate the process. Judges develop a sharp instinct for behavior patterns, and Bloom's pattern is clear: delay, disrupt, destabilize. The judge's ruling accomplishes three things: protects officers and courtroom staff, maintains courtroom order for future hearings, prevents Bloom from using physical presence as a weapon or intimidation tactic. Critical viewer question: at what point should a court draw the line between a defendant's rights and the safety of everyone in the courtroom?
Thank you. I assume Mr. Bloom heard this. Yeah, okay.
Yes, he's there,
I understand.
but he also pretends he can't hear like he did the last time. So I assume he can.
I will
Alrighty.
go to the jail and inform him of what we're doing on Thursday.
Thank you, folks.
Thank you.
14A stands in recess.
This closing moment transitions us into a new case. But before the court moves forward, it's important to understand the full picture of what happened with Jeffrey Bloom. Judge Simpson faced a defendant whose behavior had escalated far beyond courtroom misconduct. The threats were explicit: assaulting officers, throwing feces, attempting to disarm law enforcement in open court. Under Michigan law, such threats justify immediate removal from the courtroom because safety outweighs physical presence when the defendant creates the danger. The defense attempted to argue for leniency and in-person appearance, but the judge weighed credibility, officer testimony, prior incidents, and Bloom's instability, and ruled decisively. Remote participation protects everyone while still preserving due process. The adjournment was brief and strategic, ensuring both sides have time to prepare while avoiding unnecessary delay. Witness scheduling, prosecutorial readiness, and courtroom efficiency all factored into the ruling. Ultimately, this case highlights a core truth about the justice system. Courts must adapt when a defendant's behavior threatens the very environment where justice is administered. Judge Simpson maintained safety, fairness, and procedural integrity, all while navigating one of the most unpredictable defendants he's faced. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.